impressive. So we're just going to keep it rolling. We're going to keep it rolling. Jerry, I'm calling out over to you. At the inception of this country, the grand jury served as a tool for all of us, the citizens, to fight back against what could be an oppressive government, ensuring that the public, that we, the people, had an essential role in protecting the rights of the person who was being accused and the witnesses who were being called to testify, while the government investigated as to whether a crime had been committed. However, as time goes by, the grand jury has really become a mechanism where the government controls the process, not the people. While those accused of a crime and those who are asked to testify are afforded very few rights, give us a few concrete solutions for how to readjust and get our grand jury system back to functioning the way it was intended for us all.
Good morning. So, as a very young lawyer, I had a case in federal court before a very famous federal judge in New York by the name of Marvin Frankel, who had written all kinds of treatises. And I really believe my client was innocent, and the grand jury was about to consider charges against him. And I asked the prosecutor, would it be okay if my client told his side of the story to the grand jury? And the prosecutor says, we don't do that. Mm-hmm. So I go before this famous federal judge. I was 27 years old. And I said, Judge Frankel, I believe my client is innocent. I want him to testify before the grand jury that's considering charges against him. Judge Frankel says to the prosecutor, why not? And the prosecutor says, well, we just don't do that. And Judge Frankel said, what do you have to lose? Well, ladies and gentlemen, that is our system. In most places in the country, save for about a dozen states, you can't, if you want, testify before a grand jury that's considering whether to charge you with a crime that could alter your life, simply the charging of a serious crime. We all know that nothing ever leaves the internet. So your life and your ability to get employment, housing, can all be affected by a process that's totally controlled by the prosecutors. Henry Hyde, a congressman from Illinois, conservative Republican, who chaired the House Judiciary Committee, said this: the grand jury is a total captive of the federal prosecutor, who could indict anybody at any time for almost anything. Or another famous judge said a prosecutor could indict a ham sandwich before a grand jury. So what we proposed, and what is now going on in many states, not many, not enough in my view, maybe a dozen states, is the right for anybody who is under investigation to waive immunity and testify before a grand jury and to have the advice of a lawyer. And also to require the prosecutors simply to present evidence before the grand jury that they know is favorable to the accused, what they call exculpatory evidence, or evidence that would support a proposed defendant's statements. So these simple reforms would do wonders to avoid many people facing criminal trials. In addition, judges ought to be able to look at what occurred before a grand jury. You know, you can't be forced to trial after an indictment unless there is what they call probable cause, evidence before a grand jury that makes out a prima facie case. Well, who is to look at that? In the federal system, judges have no right to examine the grand jury. Every state should allow judges to examine the evidence before the grand jury to determine whether there is enough evidence to force a defendant to trial. And also have the power to reduce the crime, because we know many times people are overcharged. Yes. And they're really, what they've done is much less. And so a judge ought to have the ability to look into that. 3 basic reforms. Simple, but would go a long way to providing fairness. And the Foundation for Criminal Justice, of which I'm now president, is all about the front end and fair procedures. You know, today, and we all know that there's biased media on both sides, but there's an Associated Press story, an investigative story that's out today. The first 2 sentences: more than 40% of the 157 people exonerated last year on wrongful convictions had pleaded guilty to those offenses. How does that happen? How does it happen that 40% of people who plead guilty to things that they were ultimately exonerated for? Well, we have a system where there's not competent counsel, there's overcharging, there's a threat by the prosecutor. If you go to trial, you'll face 15 years. If you plead guilty, you could have 3. So people are in this sort of state of not knowing what to do, not really active and competent and resourceful counsel, and left to their own device. And so this is a system that really needs our attention. And hopefully all of you will go back to your states and think about grand jury reform, among other things. Thank you.
Thank you, Jim.